Oswald K. Senyaja from the Faculty of Law, KNUST. I'll be handling this course by code name PSM 558, Business Law and Contract Management. This is a course which has two components: the business law aspects and then contract management. Two separate courses put together for this program, and by the slides we are providing, we give you a brief introduction, then other contents as we continue. So business law and contract law, first will be the basic principles when you want to do business law, because we don't have just business law, a separate law, but it consists of different aspects of business transactions. So business law concerns various laws that govern or regulate all business undertakings and transactions. However, the fundamental statute to be considered in this regard is based on the Contract Act 1960 or Act 25. So this will be the basic law we'll be using in discussing business law. We'll consider first and foremost what is business and what is business law. You must know the differences between the two. Then the sources of business law. Every law has a source of authority that we can refer to when we are talking about business in a particular area. Then we also have to understand what is a contract, which is the basis of any business transaction. The underlying principles of law of contracts is very important, so we'll discuss that also. And the broad classification of contracts. Contract can be classified by the contents, by the subject matter, and the number of participants can determine what type of contract we have. So we look at all that, the broad classification of contracts. Then we look at forms of a contract: deed, simple, and oral contracts. The parole evidence rule, we look at that. Then the formation of contracts, how a contract is formed, a valid contract. Then contents and terms of a contract. Then we look at vitiation, factors that can vitiate a contract. Then discharge of a contract. Then remedies of a contract. These are the areas we look at under the business law or the business and contract law. First and foremost, since business law is the basic principle we are going to consider before the contract management, then we have to look at that. What is business and business law? When we talk about business, it's any undertaking or transaction carried on for a gain or a reward. So business always have a profit motive, a motivation. It is the activity of making or buying or selling or supplying goods or services for money. Otherwise, then it's free of charge or for pleasure, or you are giving the thing out on gratuitous basis, just for gift free. All undertakings with profit motive, we can refer to that as business. So business may take the form of different ways. Following can be given. Business, a trade can be a business relating to exchange of goods and services for money. Business can be professional, relating to the use of intellectual skills by a practitioner or by a professional body for a fee. It could be a vocation relating to the regular occupation like repairs, cleaning, or manual skills, as somebody doing painting, sculpture, and interior decoration. Anything you do for money, and you use your skills, your competence. It could be a hiring relating to paying money to borrow something or to just do a car business hiring, room hiring, video, or hiring a professional, like even hiring a lawyer is professional. So in a nutshell, business law actually is the aggregate of legislations, accepted legal, judicial precedents, standards, rules, all that govern or regulate business relations in any particular state will be the business law. So we can see the sources of business law, which is following on the scripts, and the slides will show that. And a business law will be sum total of all legislations, all the laws, all the bylaws, all the legislative instruments, all regulating the undertaking of a business. We can refer to that as business law. So, what are the sources of business law in Ghana? When we talk about a source of law, we mean two things. First, it may mean the authority from which the law of a state springs, for example, the current constitution, or enactments by parliament, or a decree by a military government. All these are described as formal source of law. And the second meaning, when we talk about sources of law, is the source from which the rules of law are derived and are referred to as the legal source. So under the second meaning, the law of Ghana has three sources, namely the common law, including equity and customary law. And the question of source of law in Ghana is answered by our country's most authoritative legal document, the Constitution of Ghana. So when you refer to Article 11, Clause 1 of the 1992 Constitution, the sources of law in Ghana have been provided. You can read that. Everybody needs to refer to the Constitution and look at the sources well provided, explicitly displayed in the book. And the Constitution is the supreme law of our nation. It's the highest law that we all obey. So the primary source of law in relation to business transaction is the formal source, which is a statutory law. So though the Constitution is the highest law and is the overall supreme law from which other laws spring, specifically business law or contract law is regulated by other sources of law, which we call the primary source of law. So we are referring to the statutes or laws made by parliament or under the delegation of power to other bodies to make such laws on parliament's behalf. So we have a few of them to list here. As you can see on the slide, we have Insurance Act, the Labor Act 2003, the Contract Act, which we'll be looking at more, the Contract Act 1960, then the Mortgages Decree 1972, NRC Decree 96, then the Conveyancing Decree 1973, Bills of Exchange Act, the High Purchase Act, Sale of Goods Act, Auction Sales Law, then the Insurance Law. So the conveyancing, we have already mentioned that. And we can refer to all of them as laws which are related to business transactions or business relationship in Ghana. But we'll concentrate on the Contract Act 1960 itself. There may be Sale of Goods Act. So we are not going to delve into all these related laws or statutes. So we only consider the Contract Act and the Sale of Goods Act 1962. These will be more relevant than the others, unless we want to go into the specifics. So the question is, what is a contract? Because we try to identify ourselves with the way and methods of managing a contract. Then we have to know what is a contract in the first place. So contract has been defined in several ways, but we'll be concerned with the most authoritative and the most reliable source. William Hansen has defined contract as a legally binding agreement made between two or more parties by which rights, obligations are acquired by both parties. That is, one party to make an offer and the other party to accept by action or forbearance. Forbearance is omissions or not doing something to the benefit of another person. When we take Sir Frederick Pollock, in his book Principles of Contract, 1876, he defines contract as promises or set of promises the law will enforce. By complete, or this one we talking about enforcement of law by not just any court, but a court of competent jurisdiction. So it is an exchange of promise between two or more parties which is intended to have legal consequences. It does not always require formality. For example, engaging a carpenter or entering a contract of carriage does not need any formality. Bonson Simpson, is a Ghanaian, also wrote and defined it as a contract which is an agreement between two parties who have capacity for a price, which is consideration, and measured in terms of money, effort, forbearance, or exchange of promise, which is enforceable by court of law. So his definition combines all the essential elements of other definitions. So we realize that when we look at these definitions of contract, there are some very important elements running through all the definitions, and I can pick all these together to make a real composite definition of a contract. So a contract must be an agreement between two or more people. A contract must be enforceable in a court of law. People making the contract must have capacity, and a contract must be legal and within a territory of our nation or Ghana's jurisdiction, not outside. So it's only effective within the jurisdiction of Ghana and not outside. So all the laws made in Ghana are effective within specific territorial area. So by definition, we know a contract must be an agreement, an offer, and acceptance, but there are other elements which are necessary to make it a valid contract. We'll look at that later. Now, when you make a contract, there are certain principles which we have to consider and take into consideration when making such contracts or transactions. These principles constitute the theoretical foundation of a contract. They are themselves not contracts, but they guide those who are entering into contracts. One of them, or the principles, one of them is sanctity of a contract, freedom of contracts, contracting party beware, reasonableness, intolerance of fraud, protection of innocent third party purchaser. So looking at that into details, the first one, sanctity of contract. What do we mean by that? In fact, it's clear that parties are free to determine the terms of their own contracts. Nobody will make the contract for another person, but they themselves might decide what to put down as their agreement. So the contractual obligations voluntarily undertaken under a contract are therefore sacred and should be observed by all parties as such. So when you decide to enter into a contract with another person or another party, you are not coerced, you are not pushed into making that contract. You have decided and consciously agreed to it. And therefore, the principle is that you must obey that contract. You must observe that contract. You cannot refer to any other situation as the basis of your refusal to obey what you have agreed upon. So, sanctity of a contract means you must genuinely accept what you have agreed upon and observe it. In other words, we say, pacta sunt servanda. You must observe your own agreement. Pacta sunt servanda is a principle known even not only in local law but international law. And therefore, you cannot refer to any situation for not being able to fulfill your promise. It's very common. Practically, we refer to other situations for not obeying our own law or agreements. It's raining, I couldn't fulfill my obligation, I had to pay my children's school fees as an excuse, or I'm sorry, I could not make it because I was sick. These are all excuses we give in order not to really observe an agreement. We have to desist from that. So a case study is the Printing and Numerical Registration Company versus Samsung. In that case, held that contracts, when entered into freely, shall be held as a sacred right by all parties without giving excuses as to the failure to fulfill its obligation. So it should be faithfully respected as binding. Faithfully respected as binding. So you cannot refer to any other situation for not fulfilling it. You see, usually when there is no witness to some of our agreement and promises, we easily bow down, we easily reject our own agreement, we easily do not accept what we have agreed upon because there is no witness there to testify. But consciously, every person has to observe, irrespective of whoever is a witness. And that is the principle number one. Now, another principle is the freedom of contracts. This principle originates from laissez-faire doctrine, which promotes the idea that since parties are the best judges of their own interest, they should be free to make contracts on any terms they choose. Since parties have agreed to enter into a contract and can be the best judges of their own interest, they should be free to enter contracts on any terms provided not prohibited by law, or provided they have capacity. As for capacity, will be an underlining principle. So on the assumption that nobody will choose unfavorable terms, they must all be the best judges of their own agreements. Parties are at liberty to voluntarily enter into any kind of agreement that they do so desire, unless they do not have capacity. Hence, a person may not be under compulsion to enter into a contract. So you cannot be coerced or forced to sign a contract or to enter a contract. It must be a free will. The courts are reluctant to intervene, though may at times intervene on the basis of fairness. So you have to write your own contract. It's not the court that is going to write the contract for you, but you must do it free willingly into any area that is not prohibited by law in Ghana. You are at liberty to enter into that agreement, or where the agreement is not illegal or does not border on legality or prohibited actions or relations in Ghana, then you are free to enter such an agreement. The third principle is the caveat emptor. The principle of caveat emptor, let the buyer beware, which is the explanation, it applies to contracting parties themselves. A contracting party is to ensure that due diligence is taken, the warranties and undertakings are verified to reduce the risk. So parties must seek professional advice where and when necessary. Professional advice where and when necessary. You cannot blame anybody for entering into an agreement which you are not very sure of. You have no idea of the circumstances under which you are entering into the contract. If you want to make a contract with another company or institution, it is the parties themselves that must investigate into the credit worthiness, the capacity, and all the rest related to the other party before you enter into a contract. It could be misled, misrepresented, but the partners are at liberty to find out about the other or the opposite party, so that you can reduce the risk when you enter into an agreement with another party. The next one is the intolerance of fraud. Fraud is wrongful, fraud is criminal, deception intended to result in financial or personal gain. So generally, law does not tolerate fraud, because we say fraud omnia vitiates. Fraud vitiates everything. Fraud destroys everything from the beginning of the making of the contract up initio. So fraud can be something that will vitiate a contract and must not be tolerated. The next is the protection of innocent third-party purchaser. Protection of innocent third-party purchaser has developed to be a principle that people should observe when they are entering into a contract. The law of contract protects the third party who, without fraud or deficiency, obtains a contractual benefit. But the strong word here is innocent third party. How innocent are you to prove? So unless you prove that you are innocent of a fraud-related transaction, the law will protect you. You must not leave it unprotected. And therefore, every party must really be innocent about it, which is the most difficult aspect of it. It's difficult to be innocent when somebody sells to you a stolen goods and the owner now wants to take back the product from you. You could only be protected by the law when that act has been innocently done. What entails innocence? To your level of understanding of the innocence is that you are not aware, as a normal human being, you are not aware that it's a stolen good. The person selling you that good, is he the retail person? Is he the owner of the property? Is he paying tax? Do you believe him to be the owner, the rightful owner? Is he dealing with that part? You buy goods on the streets. What guarantee is there that he is the dealer, the proper or the original dealer or owner of the property you are buying? So your innocence must be proved, which is difficult one. If you can prove it, then you retain the product, even if it's a stolen product. But you must prove that you are innocent, you have not been sold a stolen good. So it's not just every stolen good you will be allowed to retain it. Now we can go to the classification of the law. Business contracts may be classified into different categories. It could be by their object of transaction, or the number of parties involved, or the mode of the transaction. So I have made that into three main categories. When we say by object of transaction, Then we're talking about contracts of barter and exchange is based on the object. A contract of bailment, a contract of hire purchase, a contract of loan and securities, a contract for supply of goods, contract of sale of goods, a contract of agency, or a contract of licenses of intellectual property, a contract of real estate, or a contract of guarantee. These are different types of contracts based on the objects of transaction. The objects of transaction. They are all contracts, but we differentiate them by their object to identify what type of object they are dealing with, what is the nature of the work or the transaction. We can also classify them under the number of parties involved, but actually in contract law, we have the main one as the bilateral contract. Bilateral contract, which is two parties where there is fulfillment of reciprocal obligation. When you enter into a contract, there is a reciprocal obligation that I'll supply goods, and the other side has an obligation to pay for the goods. So it's reciprocal. So you have rights